Hello friends. Today we are going to discuss about Advance Directives and Nominated Representative under Mental Health Care Act of 2017. I am Dr. Suresh Badadmat, Professor of Psychiatry, working at NIMANS, Bangalore. Before I start my presentation, I would like to place this disclaimer. This presentation is for academic and training purpose only. For legal opinion, please do contact an advocate. This video is not an alternative or a substitute for professional legal opinion. Conflict of interest? None. This video is made with an objective of to discuss the Advance Directives and Nominated Representative under Mental Health Care Act of 2017. This video is targeted to doctors, psychiatrists, mental health professionals such as clinical psychologist, psychiatric social worker, and psychiatric nursing. This video is also helpful for persons with mental illness and their family members, Mental Health Review Board members, State Mental Health Authority and Central Mental Health Authority members, and also advocates and police. Let's discuss about Advance Directives and Nominated Representative under Mental Health Care Act of 2017. Mental Health Care Act of 2017 received President Assent on 7th of April 2017. This legislation was passed in the Parliament with the primary goal of providing mental health care and services for persons with mental illness, at the same time to protect, promote and fulfill the rights of persons with mental illness during the provision of services. These are the two important goals which was there for Mental Health Care Act. One is to provide services and to protect the rights of a persons with mental illness during the provision of services. So these are the two important goals which is there under Mental Health Care Act of 2017. But however, please remember the heart and soul of the legislation is the enumeration of the rights of persons with mental illness from section 18 to 28. But however, the rights are there from section 5 to 28. So let's discuss about those rights. One is Advance Directives, that is section 5 to 13, Nominated Representative from section 14 to 17, and rights of persons with mental illness from section 18 to 28. In this video, I am going to discuss one is Advance Directives, another one is Nominated Representative. With regard to rights of persons with mental illness, I am going to make a separate video. Let's discuss about Advance Directives, that is from section 5 to 13 under Mental Health Care Act of 2017. Advance Directives means every adult shall have a right to make advance directives in writing. It is not just person with mental illness, every adult. And what he is going to do it in writing? He is going to express the way he has to be treated when he develops mental illness. That means it has to be in writing, it has to be registered with Mental Health Review Board, and he is going to express telling that the way the person wishes to be treated and cared if he develops mental illness. One, the way the person wishes not to be cared and treated for a mental illness. That means it is a living will. This living will needs to be written, it has to be registered. He will mention how he should be treated if he develops mental illness, how he should not be treated if he develops mental illness has to be clearly in writing. Further, he can nominate nominated representatives for providing care if he develops mental illness in order of precedence. So, invariably, if there are no NR, the family members are the one who is providing care. But to uphold the rights of persons with mental illness, in this legislation, every person has a choice to make any person as a nominated representative. And it has to be in writing and it has to be registered with the Mental Health Review Board. Let's understand the applicability and amendment of the Advance Directives. Advance Directive shall be invoked only when the person develops mental illness and loses capacity. Otherwise, the person's will and wish will be respected. Only when his capacity ceases, then only the Advance Directives will come into play. At the same time, Advance Directive is not applicable in emergency situation. And another important thing is, Advance Directive is only for mental health care and treatment. The Advance Directive is not applicable for finance, for property related issues, or anything other than mental health care and treatment purposes. Further, an advance directives made contrary to the law will become null and void. Suppose a person with mental illness or any adult writes, if I develop mental illness, a lethal injection should be given to kill me. If such advance directive is written, it becomes null and void. And advance directives can be amended by only two people. One, the person who has made, or else mental health review board. These are the two agencies who can change, amend, or write the advance directives. Let's understand the process, how the advance directive is implemented. A patient or the NR responsible should provide the advance directive to the treating psychiatrist. That means if a person develops mental illness and he is taken to the mental health establishment, in the mental health establishment, either the patient should say, or else the NR or the accompanying person should say, Sir, this person has made advance directives, please look into it. And once the advance directive is given to the registered medical practitioner, it is the duty of the medical officer to follow the advance directives. That means he has to follow it. However, if there is any side effect or else unforeseen consequences occurs when following the advance directives, the medical officer will not be held responsible. For example, if a patient has written, if he develops mental illness, he has to be given injection haloperidol deconate. And the medical officer feels and also thinks that this advance directive is valid legally, he gives haloperidol deconate injection and the patient develops dystonia. The doctor will not be held responsible because the doctor is following advance directives. At the same time, it is the duty of the state government to make this advance directive available online, and it should be secured. It should be made available only to the person who is providing care. Let's discuss about nominated representative. That is from section 14 to 17. Every adult shall have a right to appoint a nominated representative, and that NR shall be an adult and gives consent to execute his responsibility under this act. And this should be in writing and should be registered with the MHRB, and invariably it is a part of advance directives. Imagine if there is no nominated representative has been registered or else advance directive is not written. What will happen in such a scenario? As per the legislation and as per the precedents, the NR will be either the relatives or the family members, or else the caregivers, or else suitable person appointed by the mental health review board. If a person with mental illness is homeless, nobody is there and he is an orphan, board, that is mental health board, shall appoint the director, Department of Social Welfare, or his designated representative to act as an NR and to act in the best interest of the person with mental illness. This is how it should be done if the advance directive is not made. In such a scenario, either the relatives, caregivers, or suitable person nominated by the MHRB, or else the director, Department of Social Welfare, or his representative on order of precedence will be considered. Let's understand the role and responsibility of the nominated representative. The NR should consider the current, past wishes of the persons with mental illness, his values, history, culture, and the best interest of the person with mental illness. He has to take a decision. Providing support to persons with mental illness for taking a decision on mental health care related such as admission, treatment, and discharge and rehabilitation. That means NR will act only for the purpose of mental health care and treatment and rehabilitation. At the same time, NR can seek information regarding the admission, treatment, and what are the sections the person has been admitted. At the same time, NR can approach Mental Health Review Board on behalf of persons with mental illness if there is violation of rights of the person with mental illness. At the same time, NR can also appoint an attendant. That means, imagine if NR is very busy and he may not be able to take care of the person with mental illness on day-to-day basis. In such a scenario, NR can appoint an attendant. At the same time, NR also can give consent for a research on person with mental illness. But however, NR should follow supported decision making. You should not follow the proxy decision making or a surrogate decision making. Let's discuss the decision making. The decision making, there are three types. One is rights based decision making. Second one is supported or shared decision making. Third one is substitute decision making. If you look at the spectrum of decision making, on one extreme, it is rights based decision making. On the other extreme, it is proxy decision making. In between, it is supported or shared decision making. Let's understand from the perspective of marriage. Imagine Mr. X falls in love with Miss Y, and then both of them get married irrespective of their family's opinion. It is rights based decision making. Now, coming to the other extreme, arranged marriage. Irrespective of the bride or the bridegroom decision, the family takes decision of the marriage. That is proxy decision making or else surrogate decision making. But however, in the current scenario, most of the time, the family will place some of the requirement. That means he has to be from the same gender, from the same caste or religion, and they will allow the bride and bridegroom to choose from their religion. That means it is a shared or supported decision making. Here in Mental Health Care Act of 2017, where the collective rights prevail over the individual rights. In such a scenario, family plays a very important role in providing care. It is not the government which is providing care. It is the family members who are providing care. Hence, even in Mental Health Care Act 2017, that shared decision or supported decision making prevails. That means the decision is taken jointly by the patient and the family member. One more example I would like to give you. If you talk to a person and say he needs to undergo operation today, immediately that person may not give consent. He would like to know the information and he will discuss with his family member. And a couple of family members would like to come back and discuss, and finally the decision is made. That means it is a shared decision making or supported decision making. Another example I would like to give you. If you are a doctor or a clinical psychologist or a psychiatric nurse, you are highly educated. If I ask you what kind of car you would like to buy, and you have decided to buy a car, which one you will buy, where will you buy, what color will you buy, and what brand? If I ask such question, immediately you will start thinking. You will may go to internet, search for information. You may contact your friends. You may talk to your family members, relatives, or else you may visit showroom. You may do a test driving. After 1 week, you will take a decision. You being highly educated, you took decision after gathering information, taking support from various people. That means again, you being educated required support. That is called as supported decision making. Imagine for a person with mental illness. Here also they require supported decision making. Hence, the spirit of Mental Health Care Act of 2017 is supported or shared decision making, not proxy decision making. Further moving to when does the nominated representative status can be changed. This nominated representative's status can be changed by the person who has appointed him, or else the family members need to approach the mental health review board, or else caregivers, or else the psychiatrist can approach the mental health review board asking to change the NR. At the same time, only the mental health review board can amend the NR status. So, these are the way the revoking of the NR status can be done. Further, this will be decided based upon if the NR is not acting in the best interest of the person with mental illness. That's very essential. All persons with mental illness shall have capacity to make mental health care or treatment decision but may require varying degree of support, hence supported decision making. NR should enable this supported or shared decision making. How to make and execute advance directives and nominated representative. This process has been well defined in mental health regulations, either in the Central Mental Health Authority regulation or else in the State Mental Health Authority regulation. It is placed in the Chapter 2, that is Advance Directives. To make or to amend AD, a person who desires to apply to make an Advance Directives, or else to change the Advance Directives, or to revoke the Advance Directives, or cancellation of Advance Directives has to be done in Form A. I will discuss this Form A shortly. This Form A should be made available free of cost in every mental health establishment, irrespective of public or private, and it should be made available free of cost. The NR who has accepted the responsibility shall sign the request for Advance Directives that he is going to take care or he is willing to act as the nominated representative if the person develops mental illness, and Advance Directive shall be signed by the two witnesses. Every application for Advance Directives shall be registered with the board, having the jurisdiction where the person resides. If Mr. X is residing in Jayanagar, Bangalore, he needs to register his Advance Directives in the Jayanagar jurisdiction, whichever mental health review board comes in, and no fee shall be charged for registration of Advance Directives. At the same time, the board shall make the copy of the Advance Directive available for the person and all the NRs, and it also will be made available securely online. At the same time, no person, including Mental Health Review Board, shall release any copy of the Advance Directives or information in the Advance Directives to any unauthorized person or to the media. That means AD should be kept confidential and it should be made available only for the treating team, to the person and the NRs. Now, you should also remember there shall be no restriction on the number of times an Advance Directives can be amended, unless there is a period of 3 months between two amendments of an Advance Directives. That is very essential. And let's discuss about the Form A of the Advance Directives. Form A of Advance Directives looks like this. First, it talks about the demographic details. It talks about if there is already an Advance Directive is made, what is the serial number of that. Now, in the section 7, he'll be mentioning how he should be treated if he develops mental illness. In serial number 8, you'll be discussing how he should not be treated if he develops mental illness. In serial number 9, he is going to discuss about the allergies, side effects, any other matters with relate to mental illness he will be documenting, or else with regard to medical illness he will be documenting here. At the same time, serial number 10 talks about the appointment of nominated representatives. Here, the person can nominate any number of nominated representatives. Please remember, the person nominated should sign here and he has to accept the responsibility he has to execute if the person develops mental illness as per the Mental Health Care Act of 2017. Further, the signature of the applicant is essential, and here the signature of witnesses are very essential, and the Form A should be registered with Mental Health Review Board to be implementable. Coming to the withdrawal of the NR. If a person is nominated as NR, can he withdraw to be the NR? Yes, he can do it. But however, an application has to be filed before the MHRB telling that he wants to withdraw the NR. The same thing will be forwarded to the person, and the 3 months time gap has to be given so that the person with mental illness can make a fresh Advance Directive and nominate somebody else. So 3 months period is very essential. During this time, the Mental Health Review Board can hear what are the reason for amendments of the AD, and the decision has to be taken within 7 days. But however, please do remember the role of Central Mental Authority. The Central Mental Authority shall regularly and periodically make the recommendations how the Advance Directive should be made. At the same time, procedures for making Advance Directives will be amended as and when required to protect the rights of persons with mental illness. To conclude, my dear friends, Mental Health Care Act of 2017 is in the right direction towards the rights-based mental health care. MHRB is responsible for registering the Advance Directives and nominated representatives. And CMHA, that is Central Mental Authority, is responsible for making regulation with regard to Advance Directives and nominated representatives. And it can make rules and regulation to uphold the rights of persons with mental illness with regard to Advance Directives and nominated representatives. Thank you very much for giving your valuable time. Stay safe.